Good morning, Mr. Whitten.
Thank you, Your Honor. Good morning. Good morning, Your Honors. May it please the Court. Jonathan Whitten, Barbara Huggins with me for the City of Amesbury Board of Appeals. Your Honors, the argument advanced by the defendants in this case is the same argument that the defendants attempted in the Woburn case, and that is that the Housing Appeals Committee is empowered to strike conditions that it deems unlawful.
Mr. Whitten?
Yes, Your Honor.
Is there anywhere in your brief that you argue how these conditions that the City of Amesbury imposed have anything to do with zoning or anything to do with zoning or any of the interests that it seems to me that the local boards are looking at?
Your Honor, the brief discusses the uneconomic conditions standard. I'm prepared to discuss with the Court where the power that the Board of Appeals originates.
No, I'm not asking about the Board of Appeals. I'm asking about just getting beneath that. What is the zoning, land planning kinds of bases for the conditions that the zoning board here imposed on this, quite apart from economics? I'm just interested as to where is the source of authority for
Thank you, Your Honor. The source of authority is found in two places within Chapter 40B. First, in Section 20, under the definition of consistent with local needs. And then second, Your Honor, within Section 21, Chapter 40B, Section 21, where the board is empowered to act as if it were all other boards so acting.
Which other boards would do this kind of thing, like saying where the funding can come from and that kind of issue?
It's not so much where the funding would come from, Your Honor, but the conditions imposed would be including, as it did in Amesbury, monitoring, insurance of excess profit being returned to the city if that was relevant.
Which board would do that?
Well, it would be any board that's a special permit granting authority, but under the comprehensive permit project, that's the only time where a local board actually gets to discuss.
So the Board of Health could monitor about where the excess funding would go?
Not funding for the Board of Health, but the Board of Health could certainly impose conditions to ensure that a third-party monitoring agent was required for drinking water wells. The Board of Appeals.
But that's not what was done here. Let's stick to the funding one.
Yes, Your Honor.
Which board could do that?
Well, under the comprehensive permit process, ironically, this is the only time where a local board gets to discuss matters of economics.
No, but just going to 21.
Yes,
going
Your
to
Honor.
Section 21, you can act on behalf of any other board. So which other boards would have been able to impose this condition?
Well, the Board of Appeals is the only board that deals with the comprehensive permit process.
No. You said the answer to Justice Botsford's question was, tell me what the source is when you're doing a comprehensive, and you mentioned two, Section 20, consistent with local needs, and Section 21, which is that you essentially pull together all the other traffic, health, all the other stuff, zoning,
correct,
size, lot size. So starting with 21, which committee, board, department would have had the authority to impose the particular provision that Justice Botsford identified?
On financing, Your
Yes.
Honor, it would be limited to the Board of Appeals, and for this following reason. Only the Board of Appeals, through the comprehensive permit statute, is dealing with a statute that talks about uneconomic conditions.
So that's not Section 21.
Well, it is, Your Honor, it is 21, and here's why. Section 21 doesn't exclude the Board of Appeals from that list of powers. It is inclusive, not exclusive, of the Board of Appeals. The Board of Appeals is a local board under the statute. The Board of Appeals is the permit-granting authority pursuant to Chapter 40B.
But that's not under 21, then.
I would say it's under 20 and 21, Your Honor, and here's why. The Section 21 states in relevant part, including but not limited to the power to attach to said permit or approval conditions. And that is power.
Any conditions from your point of view?
Any conditions, Your Honor, that don't render the project uneconomic or don't violate public policy. And that is this Court's holding in Woburn, and that's the language.
Woburn never raised this issue, though. I think the assumption underlying Woburn was that the conditions that were being imposed, no one raised the question whether they fit within the powers of a local boards,
Your Honor,
collectively or individually.
Your Honor, respectfully, the Archstone brief, which was the defendant in that case, did raise, it was enumerated in their brief, it was very briefly discussed in oral argument. Attorney General Cray discussed it as being in his brief, the state defendant as well, that the Housing Appeals Committee was empowered to strike what was called unlawful conditions. It was briefed in the Woburn case, Your Honor, respectfully, and it was argued before this Court in a very short fashion because the Court's attention was focused mostly on whether an approval could be categorized as a denial. That was the bulk of the oral argument, but certainly the brief includes that, and the Court's decision in Woburn makes clear that the Housing Appeals Committee's powers are limited by statute for good reason, because as the Court says in Woburn and all the other jurisprudence from this Court, that it's a local permit issued first.
Let me ask you this.
Yes, Your Honor.
Assume you're right, if I understand this correctly, and assume, apart from your public policy issue, assume, just take the funding, and the funding hits, let's just assume, directly with what mass housing does. Goes before the Housing Appeals Committee. Housing Appeals Committee says, we can't touch this because it doesn't make it uneconomic. There's a 30A review. They haven't dealt with it, so it's not part of the 30A record. What is the developer supposed to do?
Well, Your Honor, I would respectfully disagree that the Housing Appeals Committee wouldn't deal with it, because the Housing Appeals Committee would be able to take into evidence, which did not occur here. There was no evidentiary hearing. There was no transcript. The Housing Appeals Committee could have a letter from the financing agency, the subsidizing agency, that stated the project would be uneconomic with these conditions. The Housing Appeals Committee would have a hearing, and the Housing Appeals Committee could rule that the project was rendered uneconomic, and that would be proper, and that's what should have happened here.
Uneconomic or unfundable?
Well, unfundable would be, as the trial judge said, nothing could be more uneconomic than something that's unfundable. So we certainly would agree, Your Honor, that at an evidentiary hearing, subject to cross-examination, the subsidy agency could say, with those conditions, it's uneconomic. And that's the way that...
Unfundable.
Unfundable.
We won't fund it.
Or we won't fund it.
Because we have our financial guidelines, and we don't fund stuff that is outside of our financial
That's
guidelines.
correct. The only subtlety there, Your Honor, is mass housing is not the only subsidizing agency in the world. So
you're suggesting that the developer would have to demonstrate that there would be no agency, private, public, quasi, that would fund this?
Well, I'm not quite saying that, Your Honor, because mass housing currently acts as the program administrator. So, and this Court has held that the New England Fund, a private funding source, would qualify. So it's possible that the program administrator categorically could say to the Housing Appeals Committee in testimony, this is unfundable and this is uneconomic.
And hasn't mass housing essentially said that in this case?
No, Your Honor, it hasn't. And that's the interesting and nuanced part of this case. And Judge Prasad discusses this in the colloquy that he had with counsel. Mass Housing wrote a letter saying that this project is not subject to their approval. And that letter is found in the record, and with Your Honor's permission, I'll cite to the page. The Housing Appeals Committee cites to that letter. And if I might, Your Honors, the Housing Appeals Committee specifically states that they are not including mass housing's statement as a definition of uneconomic. So mass housing could have concluded the project is unfundable. There could have been a hearing. There should have been a hearing pursuant to the regulations, as opposed to being decided on summary decision. And then the Housing Appeals Committee could have concluded, if it were proper, that the project was uneconomic because it was not fundable by any source, as Justice Cordy is suggesting. That would be proper.
So you're saying the developer has to establish it's not fundable by any source?
The developer has to establish that it's uneconomic, and that would include unfundable. So on cross-examination, one question that could be properly asked is, have you explored other funding opportunities? The regulations at the time required that. The regulations at the time required that mass housing be asked to reconsider their statement, and mass housing then would have to respond. But I want to go back, Your Honors, to the decision, the Housing Appeals Committee's decision on page 5. It's in volume 2 of the record appendix. The Housing Appeals Committee, by its own words, no question, did not take into account mass housing's letter as being a refusal to fund. They did not take into account mass housing's letter as being uneconomic. And more importantly, and this is the link to Woburn, Your Honors, and to the statute, the Housing Appeals Committee specifically said that this was not going to be adjudged under the normal circumstances, that this was not going to go through the test of, is it rendering the project uneconomic, and then are these conditions inconsistent with local needs. Instead, the Housing Appeals Committee sua sponte said, we're going to take this case and determine whether the Board of Appeals has the power to impose or non-economic conditions. Had those conditions violated public policy, as the state defendant argues, They'd be void ab initio.
Well, and who
but
would
who would
say
declare
they're
them
void?
void?
Yeah, who
Well,
gets to
you-
say what's void ab initio?
Your Honor, it's public policy. It would be as if
Who's
a
to
board...
declare
Down
public
from the
policy?
sky.
Is it to be the court or is it to be the HJC?
Well, it's certainly not the Housing Appeals Committee under the statute, Your Honor.
So you can't go there. You have to go.
Go right to
somewhere
court.
else.
You can go right to court, yes?
You can go right to court, and they're unenforceable. A restriction that violates public policy, as the Attorney General has suggested.
But you're suggesting they have to make an independent action to challenge what you've done in court. Is that right?
Your Honor, I'm not suggesting that. I'm saying they could file a declaratory judgment, but an unenforceable condition as violating public policy is unenforceable as a matter of law.
But who says?
Well, it's unenforceable as against public policy. If the plaintiff requires...
So they go ahead and build,
They
they go ahead and build, and they say, we think it's against public policy, we're just building.
Well, Your Honor, I would respectfully suggest that if it is categorically against public policy or against what we...
You keep saying against, categorically against, who decides?
Well, Your Honor, then if the plaintiff is unsure, then he would file or she would file a motion for declaratory
You
judgment.
think
They think it's categorically. They think it's categorically, and so they start digging. Can they
Well,
do that?
Yes, they can. Under the comprehensive permit statute, Your Honor, you may build even though the matter is under appeal. So, yes, they could. And the state defendant has raised issues...
I mean, no, but then you go someplace. Where do you go to stop them from building? It's not under appeal. They haven't taken an appeal. They've just decided, here are the conditions. This one is categorically against public policy. We're ignoring that and we're building. We're not taking an appeal. We're just building.
Well, Your Honor, the state defendant uses examples of a covenant that would restrict Jews. That would
I
be...
don't care what it is.
That would be against public policy. If
And they can start building and they don't take an appeal?
they could start building and take an appeal
So they're
simultaneously.
not going to take an appeal. That's the only one that's the only condition to which they object. They think it's categorically against public policy. They're going to build.
And they have the right to do that under the statute, Your Honor. And I should say,
Then what happens?
well, they would
They just build?
they would move to strike that from the record by
No,
filing a
they're not going to
declaratory
move
judgment.
just like they say. You've said, everybody knows it's against public policy. Discriminating against Jews, we'll stipulate, is categorically against public policy. So they just ignore it. They don't move to strike it, they just ignore it. Can they do that?
I believe they can, Your Honor. As they
And
would
then
if,
what happens?
well, if it were a special permit condition or a condition of a subdivision plan, it would be the same unlawful condition. If the court were to entertain through a declaratory judgment a motion to strike that unlawful condition, I think the applicant...
So you say they have to bring a separate action. Is that right?
I think, Your Honor, to play it safe, the applicant might want to do that. If the court is uncomfortable...
Want to, and you think that's what the 40B intended, that there should be this sort of separate parallel proceeding that the applicant has to follow?
No, Your Honor. No, in fact, the purpose of 40B is to expedite the
That's
development
right.
of housing. But I should say the facts of this case don't raise any claim by the state defendant or the developer defendant that the city of Amesbury raised any objectionable considerations, conditions that were violative of public policy. The debate in this case is whether any of the conditions were able to be struck by the Housing Appeals Committee without the uneconomic test.
Let me ask you, so the developer in this case, I take it your position is that they would be aggrieved by the permit that was ultimately given, and they could file an action pursuant to Section 21 of 40B under 17.
That's correct, Your Honor.
Seeking to strike those conditions which were beyond the authority of the board.
That's correct, Your Honor.
So that's their remedy.
That is their remedy.
Don't they first have to go to the Housing Appeals Committee?
Well, it depends. If they're non-economic conditions, then the Housing Appeals Committee after Woburn and pursuant to statute doesn't have authority to strike non-economic conditions.
These are separate. This would be a separate. In other words, they're conditions which the developer could say make this uneconomic.
No, Your Honor, if I might interrupt. If it's an uneconomic claim,
Right.
the Housing Appeals Committee is the proper forum.
Correct. That's what I'm saying. There'd be those conditions, and those the Housing Appeals Committee has authority to act on those, and then conditions that maybe don't have anything to do with the economics of it, but for other reasons are objectionable, would be resolved by the court.
That's correct, Your Honor, and I believe that's the statutory intent. That was the legislative purpose. The legislature could have easily changed the phrase in Section 21 from uneconomic and consistent with local needs to uneconomic or consistent with local needs. In other words,
Mr. Whitten, let me ask you this.
yes, Your Honor.
I'm looking at Section 21, and it seems to me, although you say, it's not just, each local board, it's, we just have open-ended jurisdiction. We, the Board of Appeals, have open-ended jurisdiction. And I have to say, given the language of Section 21, I don't see that there. I really don't. What I see is the intent. I think the legislative history, which we've set out, endless times, is to say what we're trying to do here is to have one place, because we are committed to low and moderate income housing. We're trying to have, instead of being yanked around between the building inspector and the traffic cops and the Board of Health, and we're just going to have one place where you can go and get all of those permits rolled up into one. I don't see here, and oh, by the way, the Board of Appeals now acting in this particular can tack on anything else it wants to tack on. I just don't see that in Section 21. So I get back to my question originally, which I think Justice Botsford asked. What's your authority to tack on these conditions? Not who can challenge them later.
I understood, Your Honor. I think the authority is found in two places. One, again, Section 21.
Which language?
The exact words would be, Your Honor, and shall have the same power to issue permits or approvals as any local board or official who would otherwise act with respect to such application.
Yeah. So if the local board, so if you want to do drinking wells, you want to do height, you want to do, that's fine. But where do you get this jurisdiction to go way beyond it to do the financing, for example?
Your Honor, nothing could be more important to a local board of appeals than to have control, or at least a say, or at least...
If this were not a 40B, right?
Yes,
and,
sir.
And whoever, maybe it's the, ZBA, I don't know who it is, it says nothing could be more important than to make sure that this thing is going to be financed and so on and so forth. Where do they get that authority?
Well, it would, again, and because it's a comprehensive permit, it is indicative that the Board of Appeals has to be, the local board has to control and manage the project. And, Your Honor, if I might say that the second half of my answer to your question is Section 23, which specifically limits the power of the Housing Appeals Committee.
I'm not
I
going to who and how they can challenge it. It's the source of your authority.
And I think the source of the authority is Sections 20 and again 21, and the legislative history, Your Honor. And I think the court held in Woburn very clearly that without that balancing test, without the determination of uneconomic, the matter must stop here.
And your time is up.
Thank you, Your Honors.
Thank you. Good morning, Mr. Goodman.
Good morning, Your Honor. May it please the Court, Assistant Attorney General David Guberman for the Housing Appeals Committee. Mr. David Gallagher will be following me for Attitash Views, the developer. Before turning to the authority of the committee to strike these non-zoning conditions, I'd just like to follow up on why these are beyond the authority of the local board, here the ZBA, to impose. And I draw the Court's attention to the Groton case cited in our brief. Groton. It's ZBA 451 Mass 35. In that case, the Court held that the Housing Appeals Committee, whose powers are the same powers, the Court said, as those of the local board when it is reviewing a decision, didn't have the authority to require the granting of an easement, because that's not the sort of authority that one of the local boards has. And the Court says at page 40 of Groton that the phrase permits or approvals, read in the context of the entire Act, refers to building permits and other approvals typically given on application to an evaluation by separate local agencies, boards, or commissions whose approval would otherwise be required for a housing development to go forward. These, as I think Chief Justice Marshall's question at the end made clear, are not the sort of approvals that would typically be required by a non-40B housing project. And I would venture that for that reason, perhaps as well, under Section 20, they violate the equal treatment requirement and could be struck on that ground as well. So the real question in the case, I think, is not the local board's lack of power to impose, but the Housing Appeals Committee's authority to strike.
Well, it's,
So we move to who, I'm sorry, Chief.
it's a combination of both, correct?
Well, yes, but I think the first question is quite easily settled without there being any ambiguity in the statutory enactment.
That's correct. Then the question is there anything in the legislative history that suggested that you had to have all of these parallel proceedings, that you had to, you know, if you thought it was beyond the scope, you'd have to, the developer would have to file their own declaratory judgment? And maybe that's why you say the focus is on the second question, which is, does the Housing Appeals Committee have the authority to strike those?
Yes, Your Honor. And I think the answer is that the Court many times has recognized that as part of the legislature's purpose to get around barriers to the construction of affordable housing imposed by zoning laws, and to streamline the process, that from an administrative point of view, everything funnels to the Housing Appeals Committee. So this raises...
But the Housing Appeals Committee is very limited specifically in the statute as to what it can do and what it can review.
Yes, it is limited, but Woburn is distinguishable, and that's the first of 2 points to which I wanted to turn. In Woburn, no one questioned, I think this is fair to say, certainly the opinion of the Court doesn't question that imposing a limitation on the size of a project is something that is classically within the authority of the local board if it's done on appropriate grounds. The problem the Court had with what the committee did in Woburn was that it reviewed a permit that had been granted with conditions as though the permit had been denied. And the Court said that the committee did not have discretion, did not have unbridled discretion to determine what conditions that, although they did not render the project uneconomic, were nevertheless so onerous as to constitute a de facto denial and change the standard of review. This case is not Woburn. This case is like those cases in which the Court has approved the committee deciding questions that are antecedent to a review of the decision of the local board under either a denial or an approval standard.
Haven't those been, number one, in regulations or guidelines, as opposed to and you were going to give me a Chenery argument, it doesn't matter whether it's the individual decision or the guideline, but I mean, if there's no guidance, what do you say about that?
Well, I am going to give you, I prefer to call it a Goldberg argument since it's your case, but yes, well, let me back up. The statute plainly imposes limitations on the board's authority to impose conditions. And the statute plainly talks about when the board is reviewing conditions under an approval standard, what that standard is. What the statute doesn't address is what happens when the board, when the committee is confronted with a condition that is beyond the power of the local board to impose. And it could be one that my brother now concedes is categorically against public policy.
But he didn't tell me what the remedy was.
Well, that's what I'm coming to. Exactly, Your Honor. The remedy, it seems to me, well, before I get to the remedy, there is a gap in the statute. And the Court says in Goldberg and in other cases, when there is a gap in the statute, then the agency, as long as it acts reasonably, may fill the gap. And the agency doesn't have to only fill it by means of regulation. It doesn't have to anticipate the creativity of a local board of appeals coming up with conditions that it doesn't have the authority to impose.
What do you say to Justice Cordy's question, though, that if you read the language in 21 as being very restrictive on what the HAC can do, and it can only look at whether it makes it uneconomic. And if the developer is unhappy about the fact that these conditions have been passed through, they've gone from the board to the Housing Appeals Committee, who said we can't look at them because they don't relate to the economics of the project, then the remedy of the developer under the last line, the last sentence of Section 21, is to bring an appeal, well, bring an action under Section 17 of Chapter 48.
Well, my attempted answer to Justice Cordy's question is that antecedent questions, such as does the developer have a sufficient property interest to bring the project within the jurisdiction of the committee. There are a number of questions that the committee decides before it reviews under the appropriate standard, and we say this is one of them. To come to what I understand your question to be, Justice Botsford, namely, what's the developer to do? We say the legislature wants the developer to be able to take everything to the committee. And the reason is because the legislature wants to streamline the process. If the developer has to go both to the committee, because it may hope to prove that these conditions or some other conditions render the project uneconomic, and to court because it hopes to establish that even if it doesn't render the project uneconomic, nevertheless they're beyond the power of the board to impose, then you have a situation in which the committee most likely has to stay its hand until the court has decided the questions before it, because otherwise the committee doesn't know what is or isn't within its jurisdiction to decide. So we have a Superior Court action, and very often, as the court will be aware, these go up on appeal to the appeals court, directly here after the appeals court. After that process, which will take some years, then the committee springs back into action, and it makes its decision. And if its decision, especially if its decision is favorable to the developer, very often we end up in the Superior Court and then up on appeal. And so we have essentially, perhaps doubled the time that this all takes. And it would be a very brave and I would say perhaps foolhardy developer who would simply go ahead and start turning up the earth and trying to build when it doesn't know at the end of the day whether a court at some stage in the game is going to agree with its judgment as to what is or isn't clearly against public policy. If I could have one word before I sit down, I want to suggest, for example, that the usurpation of the role of mass housing is very much against public policy, and it's a different kind of against public policy than protected groups. But it is illustrative, I think, of the fact that developers should not, and the legislature doesn't want them to be in the position of hazarding very substantial sums on what a court may or may not say. The Housing Appeals Committee is the place to go. If it's an antecedent question, they still have their right of judicial review, and the court can say, no, this was within the authority of the local board, so they don't lose anything. What they're looking for is an opportunity to defeat affordable housing, either by saying no one has the authority to second-guess them, or by creating...
Well, they would argue quite to the contrary. They want to make darn sure that this is affordable housing, and we know that the track record is not great on that subject, so I don't think you should suggest that their motive here is to bar public housing or low-income housing. I don't think that's quite fair. But let me ask you this, and I know your time is up. You've got the Superior Court judge described these as two different categories of conditions. One, clearly, as you suggest, in the area where the mass housing finance ordinarily sets the standards. And the judge said those clearly seem to be in a separate category from the 14 other conditions relating to what environmental rules would apply, whether they're the rules at the time of the permit or the time of the construction, which could be years and years later. What about those?
Well, my brother will discuss them in
Okay.
more detail, but
All right.
I would say, however, Your Honor, that if they're not within the authority of a local board
But
to
these would be within the authority of the local board, it seems to me, saying which, I mean, these other 14 seem to be within the authority of the local boards, no?
well, I would defer
All
to
right,
my
then that's
brother on
fine.
those.
Thank you, Mr. Gouverman. Mr. Gallagher?
May it please the Court, David Gallagher for the defendant Attitash Views, LLC. Addressing the question just asked, it's clearly at the HAC at the summary decision level. In this case, it was the developer's duty and obligation to demonstrate that the conditions make the project impossible to proceed and still realize a reasonable return within the limits set. In this particular case, there was the letter by the Mass Housing that indicated that, in fact, that the project could not proceed.
Yeah, but that letter was not taken into, I mean, if you read the HAC decision, it says it wasn't even offered for that purpose, and we're not even considering it. I don't understand why it's much relevant here.
Well, I think it's relevant, we would argue, because it is true that the HAC in this particular case did not come down and say that this project was uneconomic as a result of being impossible to proceed because of the Mass Housing letter. But
Which it could have done, and that
Which
would
it
have
could
certainly
have.
made this very different.
Correct. In particular, it could have, because there was no evidence rebutting that position at all. And we would submit that it was the burden of the board to come forward with that, and their failure to do so results in their inability to assert otherwise. But it's true. The HAC in this case found that the conditions, all of the conditions in the aggregate, were improper conditions, did not relate to issue the typical zoning type conditions as Section 21 talks about, that a typical board would assert.
So explain that to me. I understand all of the things that Mass Housing Finance has objected to as falling fairly cleanly into that category. What about these other 14 conditions?
Well, we would submit, we could possibly go through them, but I would submit
Just give me
that
some
the
examples.
HAC found that all of the conditions were beyond the authority.
But why?
Well, for instance, Section 42, or rather, Condition 42 dealt with marketing and the monitoring agent.
Okay, all right, I'll grant you that. That's
Okay.
something.
Again, 43E, assignability, that the project must be funded by Mass Housing. Again, it's a fundability issue. The supervisory authority of Mass Housing is the same whether it funds it or whether it is the approval authority. So it doesn't make any difference either way. 43A, B, D, K, L, and 59 have to do with conditions subsequent. That is, that you have to go back to the board to get further approvals of various parts of the project.
When finalized.
Correct.
Right.
And
So
again, going back to Section 20.
Why wouldn't a board ordinarily be able to do that? Say,
Well,
okay, we've approved this permit on the condition that when you finalize your plans, you come back and we look at it again.
Because again, the power of the board is derivative. That is the same power that other boards would have in other similar situations. And we cite cases in our brief, I believe in page 47, the Barlow case and others, talk about the fact that a board in a typical subdivision or some other zoning type situation cannot require conditions subsequent. So that's the reason that one, again, is beyond the authority of the board. And so those are some of the instances on some of the conditions that were not addressed by Mass Housing in its letter, but in fact were beyond the authority of the board. And again, I think it really all comes down to Section 21. The issue is it an inclusive or exclusive? And we would submit that it's very clear. If you take the board's position the language in Section 21 is meaningless, because their argument is, if a condition doesn't render the project uneconomic, we can issue whatever condition we want, including no Jews. And the reason that I would submit that council didn't answer the question as to what you do with that is because what it means is that the developer has to file a separate lawsuit. And then you have issues in regards to...
Couldn't the developer actually appeal under the last sentence of 21? That is, bring a 4817 action after the Housing Appeals Committee has acted, and let's assume you accept the city's argument that it's very limited what the housing HAC can do. As part of an appeal from that, couldn't the developer raise these issues about, the board was acting basically ultra-virus? I mean, it was going way beyond its jurisdiction, right, in the Superior Court?
I think you could do that, but again, it goes against the entire legislative history of the statute, which is to try and streamline the process. What we're now doing is adding an additional layer of litigation on top of, I mean, for instance, this case, we're almost at the 5th year anniversary.
But I assume the city could always bring the 4817 anyway, right? If they didn't like what the Housing Appeals Committee did, that's how they challenge it.
Correct. But the problem in this case would be if a developer is faced with a situation where there are both conditions which it deems to be rendering the project uneconomic and other conditions which it feels are just improper for the board to assert, that puts the developer in a position of having to file, both go to the Housing Appeals Committee and go to the Superior Court, presumably for a declaratory judgment. A question of whether the Superior Court would stay that case because of a failure to exhaust administrative remedies, or vice versa. It has a tremendous layer which goes against the entire legislative history of 40B. And again, also renders Section 21 of 40B meaningless, particularly the language at the end, when it talks about conditions such as height, site plan, et cetera, that are consistent with the terms of this section. What does that mean if it doesn't mean zoning type, planning type conditions, not conditions? I mean, there aren't cases in which a planning board in a subdivision context demands that the developer go to Bank of America for its funding. That's just not something that's done. And that's exactly what the board is seeking to do here. And it's, again, its authority is derivative, and it didn't have the authority, and the HAC is logically the place and appropriately the place where that should be addressed.
Thank you.
Thank you.
Mr. Gallagher.